Good morning and afternoon, everyone. I'd like to welcome you all to our final webinar of 2020. We have Bruce here from Littler, who's going to cover an employment law updates for between now and the last time he did one for us, which I think may have been about 90 days ago. And he'll look a little bit he'll use his looking glass and look into 2021 and let you all know if there's anything you need to keep an eye out on. Of course, my name is Max Smith. I'm the Communications Director for 501c Services. As many of you know, we are a 100% employee-owned company that provides full-service unemployment outsourcing programs for more than 3,000 nonprofits across the country. A couple of our programs include the 501c Agencies Trust and Unemployment Assist. Unemployment Assist helps unemployment insurance taxpayers keep their rates low through better hiring, management, and separation from employees. Many of you on today's webcast are already working with us, and we appreciate that and look forward to working with you again next year. Real quick, some housekeeping before I turn it over to Bruce. If you have questions, please submit questions as we go. Bruce will cover as many questions as time allows, but if your question pops up in your head, don't wait until the end. Go ahead and shoot it to him through the questions tab of your GoToWebinar browser. If you're here for SHRM credits, HRCI credits, you know the deal. Complete the post-event survey. It'll pop up when we close the webinar. If you don't have time right after the webinar, you will get that same poll in the post-event survey, in the post-event email, I'm sorry. Complete the survey, let me know you need the credits, and I will send them to you before the end of the week. You're looking for the materials for today's program, we will send those to you in the post-event email as well. So everybody will get a copy of Bruce's information here. Now, without any further ado, I'm going to turn it over to Bruce. Welcome, sir. I appreciate you joining us one more time this year.
Well, thanks, Mac. It's great to be here again with all my friends from 501c Services. I look forward to a rousing hour with you. A lot has been going on and a lot is yet to come. My name's Bruce Sarchet. I'm a lawyer. I'm an employment law lawyer, and I only represent employers, not employees. So I've been working a lot with businesses in the last 9 months on dealing with, of course, the problems that we're all facing with regard to this terrible pandemic and its impact on our workplaces and on our lives. Very sad, unfortunate times for all of us. Good news on the vaccine front around the corner, and that's going to present its own challenges in the workplace as well. But how did we get here? Let's just take a little trip back in time to the last day of last year. That's right, it was New Year's Eve when Chinese health officials notified the World Health Organization about this mysterious pneumonia that had cropped up among 41 people. We've seen what's happened since then. The world's really been turned upside down. And indeed, employment law, which is what I do, employment law has been dramatically impacted by that pandemic, by the pandemic. On the 1st of January, we had a dramatic new independent contractor law go into place in California. And then by March, the federal government got into the act and passed in really rapid fashion the Ffcra, the Families First Coronavirus Response Act, which provided leave of absence for employees and tax credits to those businesses which provided the leaves of absence. So this is the first in a series of employment laws related to the pandemic that we're going to talk about this morning. Federal OSHA was sort of not too busy in the early part of the pandemic. They were just sort of hanging back there. But by July, the states started getting into the act, and in Virginia, the state became the first in the country to pass its own COVID workplace regulations, an emergency temporary standard, and we'll see that several states followed suit. So these pages of the calendar in early 2020, my friend, highlight for us sort of the big three areas of 2020 employment laws. And those are leaves of absence, workplace safety, and independent contractors. And we're going to track that In the first part of our session here together, we're going to talk about leaves of absence, workplace safety in general, with a specific emphasis on face coverings becoming more and more and more important every day. Take a look at what's new in workers' compensation, unemployment insurance, and then the independent contractor segment that I mentioned previously. And I believe if you go back in time and you look at the other webinars that I've presented for 501c services this year, you'll see that most of them are either on independent contractors or on COVID in the workplace. And then looking forward into 2021, we have a number of state ballot propositions that on the November 3rd general election, voters actually voted into place new employment laws. We'll take a look at those. And then 3 things in California: corporate board diversity, pay data reporting, and child abuse reporting. And also we'll talk a little bit about mandatory vaccines in the workplace as well. Now, I'm a lawyer and I get uncomfortable if I talk for too long without a few disclaimers, and I've got a few of them here for us today. This is a lot of information to cover. We're not going to cover everything. And here, pay attention to this third bullet, my friends, because some of these slides are going to be more wordy than usual. We're not going to have time to sit here and read all the words on some of these slides. So we'll be clicking through them relatively quickly. Those of you who have seen me present before know that that is the way things go when I'm got control of the clicker. And but you will have, as Max said, the slides available to you following the seminar. And as always, this webinar does not substitute for the advice of counsel. So with that, oh, and by the way, do please keep your questions coming in as they come up. I've got little dividers that you'll see like this throughout the presentation. And when we get to one, I'm going to just stop. I'll look at the questions and see if there's 1 or 2 that we can take at that time, rather than waiting for the very end to do all of the questions. We'll try to tackle as many of them as we can as we go along. So travel with me back in time. I'm going to close my door for just a second here. Sorry, my friends. That's a rookie mistake. I'm sorry. Approximately February 2020, when people are getting sick from COVID-19, from this coronavirus, and yet we're still going to work, right? This is before all of these shelter-in-place orders. And the thinking was, hey, sick people should not be going to work. That's just going to make things worse. But people need to work to survive, and so unless you have paid sick leave, you're going to still go to work, and that's going to spread the virus. This is a problem. The federal government asks, how can we help? What can we do? How can we resolve this? And they came up with the idea for employers to provide mandatory paid sick leave, and then the government would reimburse. The government would fund this through tax credits. The very first time in the history of our country that we've come up with a solution like this. It's relatively creative, but the problem is this: leaves of absence laws in the United States are incredibly complicated as it is. Tax law in the United States, need I say more? All you need to do is just say those 2 words and everyone goes, oh, great, tax law. So we take 2 very complicated areas of the law and we impose them, new obligations, in the middle of a pandemic on businesses, which are just trying to figure out how to get through to the next day. And now we've got all these new laws to think about and try to comply with. So not necessarily, I mean, it's a creative idea, but not necessarily the most artful way to go about solving the problems that we faced. The Federal Families First Coronavirus Response Act provides 2 buckets of leave: paid sick leave and paid FMLA. And here's my first example of a lot of words on the slide. We're not going to drill down into each of these concepts, but basically for the, oh, here's an important note though that we will bring up. Ffcra applies only to businesses with fewer than 500 employees. So if you have a nonprofit that's got more than 500, you didn't need to worry about Ffcra. I have a feeling that most of our listeners, our viewers here today, fall into this under 500 category. Now, there are 6 reasons why you can take paid sick leave, and you'll see them here on the screen. The one that maybe is the most tricky or troubling is number 3 here: experiencing symptoms and seeking a medical diagnosis. which basically sort of puts it on the honor system, because there are FAQs interpreting the Ffcra that basically say, yeah, you can't really ask for a doctor's note for this kind of absence. So that's the paid sick leave component. And then here's the paid FMLA, where an employee is unable to work because, and this is in that orange box there, they have to care for a child because their school is closed. So basically one reason why you can get emergency paid family and medical leave under the Ffcra. Now, as I mentioned, there's a payroll tax credit for this, but it excluded healthcare workers and emergency service workers. It also expires in just a few days. And remember that it applies only to employers with fewer than 500. So the questions started getting asked on March the 19th, the day after the law goes into effect. Well, what about if I work for a big company? Why should someone who works for a smaller company get this leave, but a person who works for a bigger company doesn't get it? And I think the thinking was, well, bigger companies already have paid sick leave programs in place, so we don't need to put this upon them. And then what about healthcare workers? In the early days of the pandemic, the thinking was these people are too essential, so we can't be giving them this leave and allowing them to not go to work. But is that really fair? And then what about the independent contractors? And we see the intersection here of two of our topics we're going to touch on today: COVID-related workplace laws and independent contractor laws. What about them? They aren't, quote, employees. But if they get sick, should they not also have some sick leave? Why should they be driving their cars for their transportation network or delivery network platforms when they're sick? So these gaps in the Ffcra started to be filled in. And California, no surprise, leads the way. We've got a state law which fills in the gap, and it applies to employees of hiring entities. So that includes those gig workers with more than 500 employees in the US. So it fills the gap, allows for healthcare workers and emergency responders to get the leave, and applies to independent contractors as well. And then cities in California, 10 and counting, said we need to fill in these gaps too. If you do business in more than one of these cities, good luck to you, my friends. Your compliance obligations are incredibly challenging this year. These laws are very detailed. They've got they apply to different things. They have different accrual rates, on and on and on and on. Everything you can imagine, different carryover rates, different, and compliance is a big challenge. So leaves of absence laws really in 2020 have dominated the employment law arena for this, well, since March, for the last 9 months. And it's not just California. We see similar laws, these gap leave laws, in other parts of the country as well. And we just do not have the time to go into the details of all these today. If part of your responsibility is leave of absence compliance, I wish you the best of luck. It's really complicated. We do have resources at my law firm that can help with this. We've got a giant table which answers a lot of, well, pretty much all of the questions you have with regard to these kind of leaves, but it is a daunting challenge. Now, as I mentioned, the Families First Coronavirus Response Act expires at the end of the year. So these gap leave laws, many of them also expire at the end of the year. If you look at that supplemental paid sick leave, that's what SPSL stands for in California, it expires at the end of the year. Or if the Ffcra is extended, the California gap law expires when the Ffcra expires. So the question that we've all been looking at recently is, will Congress extend the Ffcra? And it looks today like they won't. Tomorrow might be different, but Congress is grappling with this relief package, right? The lame duck Congress wants to get something done, wants to get out of town and get back home for the holidays, but they're having a hard time with it. They're having a hard time finding that compromise point. And so far, the discussions have not included a possible extension of this important leave of absence law. So more and more of these have different expiration dates. You need to pay attention to this. It's particularly important. So California, you got your 10 cities and all them complicated leave laws and all the expiration dates coming up. Same thing across the country with different expiration dates. So what does this mean? Well, you need to really be tracking what leave laws apply where you do business, and are they being extended or not? So sometimes it means you have to actually go to the city council website and figure out what's going on at the city council level. Again, we're tracking all this, and I can help with that if you need the help, but you need to keep track of the extension. And then my second bullet here is say yes to a leave of absence. Maybe, especially if it's FFCRA leave, you're going to get the tax credits. So why push back if someone says, hey, I'm seeking a medical diagnosis, I've got some symptoms. A lot of our clients today are just saying, fine, take your leave of absence, we'll get the tax credit, because they want to get it off the books before the end of the year. I think we're going to see a rush on these kind of leaves of absence starting basically today. And then finally, leave of absence compliance in December 2020 is exponentially more complicated than it was just 12 months ago in December 2019. Much, much more complicated. You need to be thinking about how much resources do we have devoted to human resources? And is it enough? Because it's a very challenging time for compliance in HR. And I think that you cannot overlook the critical role HR plays. You violate one of these laws, you've got substantial liability, not to mention bad public relations, right? You want to be compliant with all the laws. You're out there trying to do good, and you have to set a good example. So it's a big challenge, and this is not the time to be cutting your allocations in HR. So that's leaves of absence, my friend and my friends. And I see, if I can get my little arrow to go where I need it to, I've got some questions. How do I make this a little bigger? I can see that there's a question. Oh, do you know if Congress passes additional COVID relief, it will include forgiveness for blah, blah, blah. Sorry, I can see it, but I guess you can't, so blah, blah, blah. Probably doesn't help you too much, sorry. Do you know if Congress passes additional COVID relief, if it will include forgiveness for SBE PPP, the Payroll Protection Act loans under $150,000, thus allowing us to fill out an abbreviated application? I do not know. I do not know. I don't know the details of that. Are there more questions, or is that it? Mac, do you see any other questions? Oh, there's one that says reasons. It ends with.
Yeah, there's quite a few. Do you remember how to pop it out by hitting that?
No, I don't. Help me.
You hit the square with the little arrow going to the left, right next to the X, and it should pop it out for you.
Square with the arrow going to the left. Ah, thank you. Yes, now I remember that. Okay, so let's take a look. If an employee is exempt from wearing a mask, we'll get to that later. We're going to talk about masks in a moment. What is the likelihood FFCRA will be extended beyond December 31st? Doesn't look so likely. Can't say for sure. How should employees handle Efmla that crosses into 2021? Great question. Unfortunately, we don't know the answer with 100% certainty, but the law expires on December 31st. And so I think you've got a real strong argument that if they've got 80 hours of leave under this law, right? Let's just suppose that they start the last week of this year, so they use up 40. Do they get to continue to use it in January? The law is not 100% clear on this, but I think you've got a real good argument that the answer is no. And if it's FFCRA, I think the government's got a good argument that you're not going to get a tax credit for that if you do continue it into 2021. So it does look like a hard stop, at least for FFCRA. Sadly, the question is a little more tricky under all of these other state and city leave of absence laws, and it may not be as clear under some of them. So you may, you'll want to really evaluate whether or not you should continue that leave into the next year. That question gets a gold star as one of the best questions I've seen recently on this topic. I've seen it repeatedly, and unfortunately, we just don't have a really great answer. This second question is along the same lines. What do we do when Ffcra runs out? Are we going to reset hours? We just don't know. Ffcra, is it only for full-time staff? No, you can prorate it for part-time. California paid supplemental paid sick leave 500 or more yep, that's right. It took effect in September of 2020. That's correct. That's what I was talking about. Can you talk about unemployment? What's going to happen next year? Boy, it's just we're going to talk a little bit about unemployment later on, but I don't have any magic bullet, any magic solution on this. Whether or not you're going to continue to get relief there. That's just a really tough one. Also, with the Ffcra, was this in addition to your other paid time off? Answer, yes. How do you calculate for a part-time employee who has an irregular schedule? I can't remember off the top of my head, but there is a way to do it. I wish I could answer that question off the cuff, but I just can't. Here's one of my favorites. I've seen this one a lot. Employee travels outside of the country and wants to return to work. We wonder if our Washington state governor's travel advisory, self-quarantine for 14 days, falls under item number 1. Probably does. Probably does. Would those up to 80 hours be available? Probably. Could it be considered a mandate or not? I don't understand that part of the question. Could require to go to a doctor to see if they still advise for quarantine? Sorry, I can't give a seminar answer to that one. It's just too many details and too fact specific. So cannot just give a seminar specific answer. Do you know if Congress passes additional COVID relief, it will include forgiveness? Oh, that one I already said I don't know too. Will documentation be required for proof for tax credits? Yes, but it's pretty minimal. It's in the FAQ section. If you go to the Department of Labor website and the FAQs on Ffcra, you'll get an answer to how much documentation. So there are no talks about extending EPSL. I don't think so. I don't think so. They're talking about the relief bill, but so far not much on extension of Ffcra. What do you do with employees who utilize all their Ffcra and refuse to come back to the office but want to work from home? Great question. No easy answer here. If they want to work from home just because they're afraid they're going to get sick when they come to work, you don't necessarily have to give that, but I think a lot of businesses are really reevaluating their work from home models and being a lot more liberal and generous with the ability to provide that. If you do allow work from home, you've got to consider a lot of different things. Telework is legally complicated. At Littler, we've developed a telework toolkit that you can buy that helps with policies and agreements and so on about that. On the PPP loan, based on my understanding, it only recognized full-time essential workers. I'm afraid I just can't give that detailed answer on PPP loans. Not a particular subject matter expert in that one area of COVID, of the Ffcra. I do have other partners that have looked at that in more detail, but that question too specific about full-time, part-time, nurses, etc. Can you require staff to use their PTO during Ffcra leave? Basic answer, no. Under Ffcra, it's a new and separate leave. Under some of the state and city leaves, you can use that overlap. You can sort of get a credit. So if an employee works 20, would they be eligible 40 hours? I think that's right. If someone voluntarily travels out of state, are they covered under Ffcra? Generally, yes. Ending 12/31/20, does that refer to the date the employee misses or pay period date? It's just a hard calendar date, regardless of when it falls in your pay period. Documentation to get the tax credit, already answered that. If an employee chooses to travel over the holidays, can you require that they quarantine? We are located in California. I think the answer to that is generally yes, that people who travel can be asked to quarantine. Okay, great questions. There was a lot of them there. keep them coming, and we'll go on now to workplace safety. And this is where my disclaimer really comes into play about too many words on the screen, right? You're going to see a few slides here that we're just going to go, okay, you're going to read that later. As I mentioned, starting in March 15th, we kind of had all these lockdowns and shelter in place. At one point, like 95% of the country was subject to shelter in place orders. We've seen it loosen up, and we've seen states reverse. And I don't know what wave we're in now. It's a terrible wave, whether it's the second wave or the third or the first. It's bad out there. And so we're seeing more and more shelter in place orders kicking in. But meanwhile, federal OSHA was really, they were sheltering in place. They weren't doing that much. And the states jumped into the gap in this order. Let's start with Virginia. A number of different requirements, lots of challenges, lots of detail in the emergency temporary standards there. We don't have time. We could do a 1-hour webinar, my friends, just on compliance with the Virginia law. Nevada, public accommodations. I bet you, Mac, that we really don't have any 501c nonprofit members who are running hotels in Nevada. What do you think?
If I knew who they were, I would be calling them up for some good rates, but I don't think so. I think you're right.
Okay, so the only thing unique about this one is that Nevada requires leave of absence to get a COVID test in the hospitality industry. This is totally unique. No place else in the country do we have this, but for today's audience, we'd prefer to be guests at these places, I guess, rather than running them. Oregon's got really complicated ETS, and ETS is the new buzz acronym for Emergency Temporary Standard, and they've got a complex set of requirements. And again, we are not going to have time to go over it. Michigan, same thing. You may have seen in the news that the Michigan Supreme Court told the governor, you don't have authority to put all these workplace regulations in. It violates our state constitution. So the state returned with, okay, basically what the governor had previously said, the legislature now says, and there are a number of requirements as well. Mac, I got a little blip on my audio. Are we okay on audio?
Yeah, you're good. You just skipped a little bit, but you're good to go.
Okay, thank you. And then here's more on Michigan. Remember I said we're going to have a lot of words on these slides. We're not going to have time to go into all of them. On and on and on and on, and a lot of details. And then we get to California, my friends. Well, California. You see that little link there at the bottom of this slide? When you get these slides, you should cut and paste that into your browser, and you should watch this 1-hour webinar. It's a recording of a webinar put on by a couple of my partners on the California emergency regulation. One thing about these regulations, all of them, is that they're all in effect now. Usually, you know, we'll get a little bit of time to think about things and get ready. But these things just go into effect immediately in all these states. And the same is true in California. So I'm going to zoom through a lot of this stuff. Take the time to watch this 1-hour webinar if you do business in California. This is an incredibly complicated standard, and it's in effect today. It breaks down into a number of different segments. There's got to be prevention plans, and you can see all of the various elements that go along with the California prevention plan under the new Cal OSHA ETS. There's directions and requirements with regard to what do you have to do if you have multiple infections. And then something called major COVID outbreaks, what you have to do in those circumstances. Employer provided housing, don't know if any of us are into that. Employer provided transportation as well, and a number of relatively thoughtful requirements, but the thing is like 30+ pages long, so compliance is going to be a challenge. And then our State Department of Industrial Regulations has also issued an FAQ sheet on the various aspects, answering various questions. And I think they just updated it again last night. COVID-19 in the workplace, as we've seen, is a rapidly evolving area of the law. And another reason why human resources allocations need to be maintained or even increased this year. You might want to hire someone just to sit there and hit the refresh button on all these web pages to make sure you've got the latest and greatest up-to-date information. Last night, California let go more FAQs with regard to their emergency temporary standard. So on workplace safety, these rules are probably the big story. And they're so big, we don't have time to talk about them in much detail here today. Let's just see if that generated any questions. I bet you it didn't. Let's see. Yes, it didn't. The only question was, will the PowerPoint slides be available? And the answer, of course, is yes. So on these emergency temporary standards and your obligation to provide a safe workplace, you really have to have someone dedicated to this and studying it and paying attention. The rules are complicated and they're not getting any easier. So let's move on and talk about face coverings. Face coverings, my friends. We have seen over the summer, sadly, this issue seems to have gotten politicized. And there was a bumper sticker I saw the other day that said something like, my freedom, my rights don't stop where your fear begins. But this is more than fear, my friends. We got 250,000 people who are dead in this country alone. The number that are dying per day in this latest wave, it's equivalent to the terrorist attacks on September 11th, 2001 every day, a couple thousand people a day. So this isn't about, your freedom or anything. It's about public health. It's about public safety. And then we see elected officials like the governor of California one day, the mayor of San Francisco the next, while they're telling us to stay at home and avoid crowds, going out to dine with people from other families, other households, setting what kind of example? We in the employment community, if you run a nonprofit, if you're in human resources, if you're just a frontline supervisor of other workers, we really have a fundamental obligation to provide a safe workplace. And that today, more than ever, means face coverings. CDC, just 10 days ago or so, now recommends indoor universal face coverings. It used to be that you could have a meeting in a conference room, and if you were all sitting more than 6 feet apart, you were okay under CDC guidelines. That was okay on December 3rd. Now, if you're in an indoor meeting, I don't care how far apart you are, put your face coverings on and keep them on. It's a pain. I am very fortunate and I count my blessings every day. I work from home. I don't have to go do an 8-hour shift wearing a face covering. I don't even have to do a 1-hour meeting wearing a face covering. If you're reporting to an indoor environment, you should have your face covering on at all times. Does that mean if I've got a private office with a closed door, I should have a face covering on? Read the first bullet. Are you indoors? Yes. Wear the face covering. I think sadly, not only do we need to lead by example in this area and avoid going out to publicized fancy dinners with other households, we not only need to lead by example, but we need to enforce these rules as well. I'd like to take you through 3 scenarios. And the first one is as follows. The supervisor is doing their job. They're being the face mask police. Good for you. Hey guys, put on your face coverings and be sure to stand at least 6 feet apart. But what if the employee comes back with, sorry about that, man, but we're on break. And the second employee says, yeah, this is our time. You can't tell us what to do. And you might think, Bruce, come on. Well, you're just making this stuff up. My friends, no, I am not making this up. I got calls about 2 weeks ago, 2 calls in the same week from 2 different businesses asking the exact same thing. This scenario where employees push back saying this is break time. So what do you do about this? Well, my advice is think safety first. Education program. Hey, come on, guys. We're not talking about anything here other than your health, your coworkers' health, and the health of your families when you go home. We need to be following these rules. It's super important today. We want to have a safe workplace. In fact, at Littler, we've developed some training posters that can help with this. Now, one thing I've noticed is when I go out, it's to the grocery store. That's about it. This is about all I do to leave the house. And I see a number of people that just don't wear the masks correctly, right? They wear it like this. Okay, that's not good because see, it can come out your nose too, folks. It can't just come out your mouth. Or they wear it like this. Okay, it's not coming out your neck, folks. You got to put it over your mouth and nose. So here's a safety poster. We haven't really marketed this yet, but I think it's got some potential, right? It really pretty basically shows the correct ways to wear a face covering. And you can see there that in the correct one, the mouth and the nose are both covered. So let's say, Bruce, the education program didn't work. Can we enforce this rule? Yes, you can make a rule and you can enforce it. And it can be enforced even when employees are on their meal break or their rest break. Here's a classic example. You could have a safety rule saying, do not run in the hallway. Do not run in the manufacturing plant. Do not run in the warehouse. And that rule is there to keep people safe. And that rule can be enforced even if you're on your break, because this is our building and we want to keep it safe. If you're in our building on your break, you can't run. If you're in our building on your break, you have to wear your face covering and you have to stay 6 feet away from other people. So you do have to be, I think today, the face mask police and make sure people are following those rules. But let's change the scenario just a bit. Instead of the employees pushing back and saying, hey, we're on break, what if they say, that's against my sincerely held religious belief? Or they say, I have a disability which makes it difficult for me to breathe. Now we are in completely different territory, aren't we? Here, you can have basic safety rules, you can enforce them, but we have to be more careful. Disability and religious discrimination require accommodation. It's not just an anti-discrimination, they're not just anti-discrimination laws, they are affirmatively requiring accommodation in the workplace. So you have to engage in what we call the interactive process and find out what's going on. Are there possible accommodations, more physical distancing? Maybe change the work schedule, maybe work from home, telework, or leave of absence. Also, these face shields that you've seen can sometimes be an accommodation, although the studies show they don't provide as good a protection as the cloth face covering, and it's don't have to be a doctor or play one on TV to figure that out, is that this stuff can travel up and under the face shield, and it's much more difficult for it to travel through the cloth face covering. All right, my dear viewers, one final scenario. Hey, supervisor says, your face covering is dirty, and that presents the wrong image to our customers. Let's say it's a retail store or a restaurant, some public-facing job. Please clean your face covering before your shift tomorrow. And the employee says, well, whatever, dude, do I get paid for that? Do I get paid for doing my laundry at home? Real question being asked by real workers today. And the answer is probably not. Just go do your laundry. If washing your face covering at home, if you can just throw it in with the rest of your laundry, which is what I personally do to wash my cloth face covering, it doesn't take any extra time. You're not entitled to separate compensation for that. And if you show up with a dirty face covering tomorrow, we'll either discipline you or we'll send you home or we'll get you an alternative, but you've got to have a clean face covering in this forward-facing job. So sort of these minute little questions about face coverings are just coming up each and every day. And let's see if that generated any questions with regard to this issue. We do have. Let's see, here's another one. What types of legal concerns should employers be aware of regarding any alleged non-compliance of safety regulations for our nonprofit? Fines. The state OSHAs and Fed OSHA can issue fines if you do not comply with the safety obligations. So you need to study the regulations and you need to follow them. What are your recommendations for deaf or hard of hearing staff whose communication is impacted by face covering? A really great question. And I think probably the easy answer is face shields and working on other, interactive process meeting with the employee to look at other possible solutions, perhaps something in the area of written communications as opposed to speaking face to face might be possible, and video conferencing like we're doing right now. And then this isn't a question, but I think this person liked my doggy face covering poster because the comment is LOL. Oh, here's one. There are also masks with a window so you can still see and read lips. Yes, I had seen that. Great point. Thank you, Stephanie, for bringing that one up. Do we need to accommodate customers with religious objections to face coverings in Oregon? I think you probably, well, I don't know Oregon state law. Title III of the ADA is public accommodations, but that's only for disabled individuals. In California, we have something called the UNRU Act, which applies to public accommodations. And so, yeah, you would have to do that in California. I don't know about Oregon state business public accommodation discrimination law, so I can't help you there from a legal standpoint. From a practical standpoint, probably good customer relations to work out something and go with the face shield again. Are there things, what are the things that we can and cannot enforce upon our employees? For example, can we make it a policy that they have to get tested if we are essential services? Mandatory testing, very, very difficult and no clean answer here. I think the businesses which are facing employees who say, I don't want to get tested, are generally sending them home and saying, I'm not going to fire you, but I'm going to presume you're positive. So you got to go home and be symptom free for 14 days and then you can come back to work. I think that's a pretty universal approach, although you really can't look that up and say, oh, here's the law which says that's what you're supposed to do. Can we create our own quarantine policies that are more stringent because we are an essential services organization? I've never thought about that. I don't see why not. I don't see why not. If we have a face mask requirement to enter our nonprofit facility, can we refuse entry to a person who refuses to put on a face mask? I think so, and I think it's the responsible thing to do, especially with the new CDC guidance. That really helps a lot, that guidance from December the 4th. So if you've got a situation where it's in question and you have this come up, you might want to go to the CDC webpage and print up a number of those in large font and have them ready to go and say, hey, the CDC says we're all supposed to be wearing face coverings indoors. Let's see. If we require an employee to be tested, do we have to pay, or can we send them to their healthcare provider or public testing service so the company doesn't have to pay? Generally, you probably would want to pay, but in every state that, not in every state, in every business that I've worked with in California anyways, there are a number of free testing locations that are available. And I have had businesses, nonprofits, provide that list to employees so that they don't have to pay. PPP issue. There's a lot of new regulations that a facility need to comply, but unfortunately the supplies needed cannot meet the demand. Yeah, testing in California, the mandatory testing requirement is going to be gigantic and people are really worried, are there going to be enough tests? Okay, those were great questions. Thank you. We are looking at about 16 minutes to go, so we've got to get on our horse here. But those really were the most important topics we were going to touch on today. There are a number of laws, states that have laws that if you get COVID, it's presumed that you caught it at work. So if you're operating in one of these states, you'll want to pay attention to that. That's it on workers' compensation. And then very quickly on unemployment insurance, work sharing programs. If you're reducing headcounts, work sharing can be a great benefit. It allows you to cut hours without laying the entire person off and the state then makes up the difference. Not in every state. An interesting blend of red and blue states offer work sharing, as you can see by the map here. If you're in one of these states that's highlighted in green and you're reducing your workforce because your business has gone down, then you'll want to look at work sharing. All right, on from COVID in the workplace to independent contractors. In California, we've got this giant law, AB5. California Supreme Court changed the test in 2018. We have to change the test and use this ABC test. The business community said, well, we've been using that other test for 30 years. The Supreme Court is legislating. That's not your job. That's the job of the legislature. And the legislature said, well, be careful what you wish for. And they passed the law AB5. It uses this ABC test. Is the worker free to exercise control over how things are done? That's the A prong. B is the work done in the core business area of the company. And C, is it a traditionally recognized trade or occupation? It takes 130 words to describe that test, and then 3,478 words. I didn't count these, my computer did, to describe exceptions to the test. And if you get an exception, then you go back to the old test, which the Supreme Court threw out. So politics, I guess, is quite ironic. 41 exceptions. Here they are. There's no rhyme or reason. There's no connection between them. They're just all over the place, all sorts of different jobs. Not accepted were these big categories. Now, I don't think we have any nonprofits that are operating transportation network or delivery network companies or are independent operators of trucks or franchisors or franchisees. So from a policy perspective, this was giant for the state, but not so important for the listeners today. Remember, this law went into effect on January 1st. By the 6th, 5 days later, there were already amendments introduced. And some people ask, well, what took them so long? We've got a brand new law and they're already going to change it. So we added 26 more exceptions to the law. This was an urgency statute, so it became effective in September. There's a business-to-business exception. And by the way, we could talk about just this one slide. It would practically take a full hour of webinar. Business-to-business exception isn't as great as you might think it would be. Enforcement by getting sued and by the Attorney General of the state or any district attorney in the state. And meanwhile, we had the November 3rd election. We'll talk more about this in just a minute, but the TNCs and the DNCs got their own special carve out. So what do you do with independent contractor law if you're doing business in California today? You should get out your 1099s. You should take a look at them and see, are these people, do they really have the right to control what they're doing? That's the A prong. Is what they're doing central or core to our business, or is it ancillary? And this is a tough question. I mean, let's say you run a nonprofit hospital and you have people in the rooms and they look out on a lovely garden, and it's part of your plan for healthy recoveries that people will have something nice to look at. Landscaping maintenance, is that part of your core business or not? Nobody can really answer it. Probably not. But I mean, that's, what if you advertise it on your website? Enjoy our beautiful garden views as you recover. Well, now you put it on your website, you're advertising this as part of what you provide. Maybe you can't contract out landscaping anymore. So in the ABC test, this B prong has a lot of problems. If you have a problem, you've basically got 5 options. You can take your contractors and make them employees. You could send them off to a temporary agency and they can issue the W-2 and W-4 and then bring them back to your business. You could, if it's something that can be done outside of California, move it out of California. We've got the craziest independent contractor laws there are here. And if it can be done in someone's basement, if the work can be done at some guy sitting in his grandmother's basement, and you don't even care if he's smoking weed or not, then fine, have him do it in Oklahoma. They don't need to do that in California. You can try to change the law. More exceptions we predict will be coming. And the risk, though, if you do nothing, is gigantic. Very complicated area of the law. Wish it was not so for those of you trying to survive. If you're giving 1099s, be careful. Okay, I'm going to skip questions on that to make sure we get through the rest of the deck. And then we'll come back to questions later on. 3 states had employment laws on the ballot in the most recent general election a month ago. Proposition 22 in California, we talked a little bit about this already, creates this new third category of worker for the drivers in these transportation network and these delivery network platforms. Will it have an impact on California's AB5 independent contractor law? Maybe so. Maybe people will realize, hey, this law isn't so great. Will it have an impact elsewhere in the United States? It possibly could as well. A great quote from an article in The Economist magazine a while ago was that California creates political winds which blow across the country. Perhaps that will be so with Prop 22. But on the other side of the country, in Florida, the legislature, the state legislature, had been debating a minimum wage increase for a while. Didn't get anywhere. Went to the voters. The voters said, yeah, we want to increase the minimum wage. So again, voters at the ballot box making employment laws. And then we come back into the middle of the country in Colorado. Prop 118 creates mandatory paid family and medical leave. It's a pretty generous program, one that the state legislature had debated also for a while, but wasn't able to come to agreement on. And finally, the voters said, enough of that, we're just going to pass it ourselves. Now, not every state has the ballot initiative, and those that do, it's sort of a complex overlay. If you're operating in one of the states that has color in it, like blue, green, yellow, or orange here, then you've got some form of a ballot initiative. If you're in one of the gray, I don't know if that's gray, what call it, beige states, then you do not. So be on the lookout for this in the future. All right, we're going to wrap up with 3 California laws which go into effect on the start of the year. First of all, corporate diversity, publicly held corporations. Well, this doesn't apply to you because you're probably not publicly traded. But in California, you've got to have if you're a publicly traded corporation, your board of directors has to have a certain number of female directors and those from underrepresented communities. It's groundbreaking, it's brand new, and it is a really unique law in California. It sort of gives you a flavor for what it's like to do business here. The law's been challenged. I mean, how can you have set-asides? But we'll see where that goes. Pay data reporting, this would apply to nonprofits. If you think back to history just a little bit, the EEOC wanted to collect information, the Federal Equal Employment Opportunity Commission wanted to collect information on what workers were paid to try to promote equal pay and break the gender gap in pay. But that was withdrawn, and now in California, it has come back. There were a number of challenges to the idea, because how do you categorize employees? In one example, both a surgeon and a bookkeeper were in the professional category. And then if you use W-2 wages, well, those reflect a lot of personal choices, whether or not to take vacation, whether or not to contribute to a 401k, whether or not to work overtime, etc. So the idea was withdrawn, but it came back in California. A pay data report is required if you have more than 100 employees, broken down by race, ethnicity, and sex within these job categories. And again, it's going to be based on W-2 data. So there, I didn't have what happened to my other 2 slides? I have 2 slides up here on a prior presentation that I thought I had here as well. I'll just tuck them in here before we deliver these slides to you all. How do you count to 100? And the answer we think is any employees anywhere. So if you got 1 employee in California and 99 in Wisconsin, you probably are subject to this pay data reporting law. But then do you have to report on everybody? Probably not. Probably only have to report on the employees who are actually in California. And then finally, if you're in California and you employ minors, M-I-N-O-R-S, beware, you have now an obligation that the people who supervise them and HR professionals are mandated reporters of child abuse. So new obligations, you've got to provide them written notification of their obligations, and you've got to provide them with mandatory training as well. We have at littler.com the following article, which highlights state laws that come into effect in January, and you can cut and paste this link from the publication you'll get. You'll be magically whisked away to this web page where you'll see an article that I co-authored, and it basically outlines all the new laws that are in effect, employment laws that are in effect in the country this year. So let's do this. Before we do that, let's go. We got 6 minutes. Let's see if we got some questions. Let's just see where we are. Da-da-da-da. Great question. What's the process for obtaining access to WorkShare program with EDD? Can't go into it in detail. There's a form you have to fill out. Right now it's a paper form, California EDD. They're going online, but you still have to print it out and mail it in. So there's a form you have to fill out, and it's pretty straightforward. Let's see. I got a question. Is there a standard independent contractor form that incorporates AB5? I have looked everywhere. There is not. The reason you've looked everywhere is because you just can't create a standard form. There's like 67 exceptions now, and those exceptions contain 12 subparts. So to draft one document that covers all situations, it would be unwieldy. I've worked with a lot of businesses to just create custom contracts for their particular independent contractors, and that's probably the best way to go. Did you say California law presumes if an employee gets COVID, it is presumed they contracted it at work? Yes, I did. It's called a disputable presumption, and yes, it means they would get workers' compensation. Basically, that's the rule in all those states on that slide that I had highlighted. Qualifications for work sharing program. Sorry, cannot give you all of those details right now, but there are definitely boxes that have to be checked. Is the EEOC requirement 100 full-time equivalent? No, I think it's head count, not FTE, and it's not an EEOC requirement, it's a California state requirement. Oh yeah, vaccination hasn't been brought up yet. It's a challenge. 42% in the latest Gallup poll said they wouldn't get vaccinated. Mandatory vaccination policies, you're going to have carve out for disabilities. You're going to have a carve out for religious beliefs. I think a lot of businesses today are going to sort of tippy-toe into this and not make it mandatory, but sort of wait for things to build up before they go to that step. So vaccination, can encourage it. Can you require it? Probably you could with those carve-outs, but I think many many businesses are not going to do that. Does the minor law in California apply to summer camps? Answer, yes. If you've got HR people or supervisors who are working with employees. Now, if you're running a summer camp, in California, you're supervising minors, you're going to be covered under another part of the mandated reporter law. The new law is when you are employing minors, you're giving someone under the age of 18 a job and a pay. Is there any extension on the due date for mandatory training for harassment based on COVID-19? I don't think so. I don't think so. I think you need to get on your horse and get that done. There's online options available. And 2 minutes ago, we got one more question. We have many employees who aren't willing to return to in-person work. We work in homes and schools, despite having work available. Any insight of whether you feel EDD may eventually catch up on claims? Our unemployment bill is crippling. I feel your pain. Unemployment in California anyways. I don't know if this is necessarily a California question, but it's in dire straits here, my friends. Our unemployment system is terribly broken. I don't have any luck, any thought that we're going to be caught up anytime soon. So all I can say is do your best and hang in there. And with that, I will say to you, good day. It's been great as always to be with you. This is a giant challenge for everybody. It's going to be more and more challenging. Leave of absence, if you take away one thing, it should be, wow, this is complicated. We need to be on for it, on top of it. Many businesses will be cutting back, but now is not the time to be cutting in HR. If you're bored, if your executive director says to you, look, we have 25 fewer employees, or we have 200 fewer employees, we can cut back in HR, get them on the phone with me before you let them do that. Because this is a complicated time for employment law. It's only getting more and more complicated. And do not be cutting your allocations in HR. So that then takes us to the top of the hour. Mac, I'll let you have the final word.
Well, thank you, Bruce. I appreciate it. Thank you, everybody, for attending today. And yes, we will get to those slides. Bruce is going to check one more time for typos.
I'm not hearing Mac. I hope that's not, it's my problem.
Battery medium.
We'll let
Now I hear
everybody
you.
know, and we'll talk to you later. Bye.